everyone, I'm Sally. Today's topic is something I have long wanted to discuss seriously. Often, when communicating with clients and friends, I find that many people still have a very basic understanding of estate planning, thinking that just making a will is enough, or they avoid discussing this topic altogether. Many people are simply unwilling to consider these issues, thinking that matters after their death are not their concern. But I believe that most people, when they are about to leave, have the greatest wish for their family to continue living well, rather than creating endless bills, various debts, and tax issues for them. Therefore, estate planning is absolutely unavoidable. To prepare for this video, I specifically studied this book, called The Canadian Guide to Well and Easy Planning. The author of The Canadian Guide to Well and Easy Planning, Lawyer Gray, resolutely gave up his career at the age of 50 to write full-time because he discovered that only about 1/3 of people in Canada have a will, and even among those who do, many of the wills are outdated and invalid. Additionally, about 1/4 of people die without any planning in place. Including accidents or sudden illnesses, they simply don't have the time to handle and fulfill their estate planning wishes, which is actually a very serious issue. From my client consultations, it seems that less than 1/10 of clients are aware of the need to make estate arrangements. However, after hearing my advice to prepare for will planning and update it regularly, almost everyone understands that this is something they should do. But perhaps because starting is always the hardest part, and without a clear direction and method, most people might find it troublesome and be too lazy to begin. However, no matter how difficult it is, it must be done, and this is very important. I will try to distill the key points from the book to provide a reference for everyone. This video will be divided into 2 parts. First, in today's video, I will introduce the importance of a will and suggest several key issues regarding wills that everyone should consider. Why should you make a will? What constitutes a valid will? How often should you update your will? And how do you choose the right executor? Let's get started. So the first question is, why do we need to make a will? What will happen if we do nothing? In Canada, if there is no valid will, it is legally referred to as dying intestate when this happens. The province of residence will directly take over the deceased's assets and proceed with probate. Each province will decide how the estate is distributed based on their respective laws, rather than considering your wishes. Moreover, the distribution methods vary from province to province. I once had a client, and when I asked her what she thought would happen to the assets if her husband passed away, she confidently replied that the assets would definitely be transferred directly to her. However, in reality, taking Ontario as an example, the inheritance law stipulates otherwise. In the absence of any disputes, the spouse's priority inheritance share is $350,000. As for the remaining portion, if there is only one child, each person receives half. If there are multiple children, the spouse receives 1/3 of the estate. If there are multiple beneficiaries, the court needs to notify all beneficiaries before approving the distribution of the estate. This can be very troublesome for families with relatives outside of Canada. Now let's take a look at the situation with children. In the absence of a will, if there are minor children under the age of 19, the Public Trustee's Office will temporarily act as the trustee of the child's assets. This process is considered both expensive and time-consuming. Do not assume that the biological parents can directly manage the child's inherited assets. Biological parents only have guardianship over the child. Providing protection and care for children requires additional application to the legal department for guardianship of the minor's property. When the child reaches adulthood, all the property will be handed over to them in one lump sum. It's really hard to imagine if a newly adult child suddenly receives a large inheritance, whether they can make a reasonable plan for these assets. Everyone can consider this based on their own family's situation. Of course, although the law stipulates the inheritance procedures, if there are still people who rely on the deceased for their livelihood, such as surviving parents, or siblings, or others with financial ties, they also have a claim to the estate. For example, if everyone made some investments together early on, and one party feels the need to withdraw their share, this would greatly increase the complexity of estate inheritance. Even if everything goes smoothly, the process takes about 1 to 3 years, and all assets that go through probate will become public information, meaning anyone can look it up. If someone believes they are entitled to a portion of the estate, they can make a claim in court. Knowing these situations, most clients would say that they do not want such things to happen when they reflect on their own circumstances. Therefore, I usually advise clients to consider proper asset entrustment as soon as possible while they are still clear-headed, including choosing an appropriate executor for their will. It's not just about the will after death, but also various pre-death entrustments, including medical power of attorney and so on. I always recommend my clients to do this. So, when issues arise, the related tasks can be carried out according to your wishes, without the intervention of the provincial government, which greatly reduces the uncertainty in the distribution of the estate. So, the second question is, what constitutes a valid will? We all know that a will is very important, but how should we go about making one? If I just write down my wishes and sign my name, is that enough? The answer is no. Each province has legislation that defines what constitutes a valid will. A will has many components, such as it must be in writing. It must clearly state who you are and who you want to leave your money to, among other things. For example, if I just write that the money should be donated to the Cancer Association, that's not enough, because there could be multiple cancer associations in a province, which would cause confusion. Similarly, if the beneficiary of an insurance policy differs from the beneficiary listed in the will, it can lead to discrepancies. Any ambiguity or vagueness can lead to problems. Therefore, a will needs to be updated continuously. Additionally, the will must clearly state who the money is going to and how to contact this person. The will must also be signed by 2 other witnesses, and these 2 people cannot be beneficiaries of the estate. They must be third parties with no interest in the estate. To summarize, a legally effective will must meet the following conditions. It must be in writing, clearly designate the beneficiaries, and be signed at the end by the person making the will. Additionally, there must be 2 or more witnesses present who also sign the will. The will must also include the date and location of the signing. Creating a will doesn't have to be complicated or expensive. There are also some websites that offer paid services for this. You can search online for online wills, and you should find many options. In theory, making a will does not require a lawyer, but consulting a professional lawyer in this area is definitely worth considering. Of course, after making a will, it is very important to choose a designated executor of the will and a guardian for minor children. These 2 arrangements carry significant responsibilities. Let me explain this in detail. An estate executor, as the name suggests, is the person who distributes the estate. If the wrong person is chosen, or if someone is named in the will without their knowledge, and only finds out they are the executor after the person has passed away, this can be a significant problem. This is because after a person passes away, all immovable property, such as real estate, will first be transferred to the executor's name before being distributed to the beneficiaries. This process is quite cumbersome. Beneficiaries of the estate can serve as executors, such as adult children, but it is crucial to choose carefully. Although executors are obligated to distribute the estate according to the will or estate law, there is no third party to supervise their actions. If they distribute the assets incorrectly or poorly, the beneficiaries can only resolve the issue through litigation. Therefore, it is not uncommon to see siblings turning against each other due to improper distribution. Sometimes, due to various taxes on the estate and the need to pay off the mortgage on the house, the amount of tedious work involved may not yield much actual benefit. This can lead beneficiaries to choose to forgo the inheritance altogether and hand the estate over to the Canadian government. I believe no one wants to see this happen. In summary, appointing an executor is an extremely important decision, as the responsibilities are numerous and very demanding. There can be more than one executor, and multiple executors can share the duties. If you don't have a trusted friend or relative, third parties, such as accountants, lawyers, and bank personnel can also serve as executors, although they typically charge a service fee, usually around 5% of the total estate. Some people also use trust to designate estate inheritance. If part of the assets in the will is left to a minor beneficiary, then an additional custodian for the estate must be designated. As I mentioned at the beginning, if there is no clear designation, even the biological parents of the child will need to submit an application to the court. This is a very cumbersome, time-consuming, and costly process. The court requires this to prevent the custodian from misusing the minor beneficiary's share of the estate. Therefore, the review process is particularly strict. When applying, you also need to provide an additional, very detailed and reasonable financial plan. Of course, some people choose to have the beneficiary's inheritance managed by the court and then distributed by the court when the beneficiary reaches adulthood. However, if during the child's growth, the inheritance needs to be used for legitimate expenses for the beneficiary, such as paying for tuition or medical expenses, it is necessary to apply to the court for each disbursement. In addition to the estate trustee, we should also choose a suitable legal guardian for our minor children to continue fulfilling the responsibility of raising them. However, the guardian designated in the will is actually just a request to the person and does not carry legal responsibility. So, if you ask a friend to be the guardian of your children, please make sure to clearly specify this in the will. Where should the funds for raising children come from? For example, clearly specifying the amount of life insurance compensation can be used for the child's upbringing and education expenses. Doing so also provides protection for friends. At the same time, I also suggest that everyone provide some additional funds as a token of appreciation for the guardian. Because, no matter how good the friendship is, it is difficult to take on the significant responsibility of raising a child without any compensation. Before making a decision, be sure to have an honest discussion with the other party. This is extremely important. I hope that after watching this video, everyone can make proper arrangements for their children. So the final question is, how often should you update your will? I would suggest that everyone review their will at a specific time each year, such as on your birthday or wedding anniversary, to see if there have been any changes in your life. If there are changes, then the will should be updated. For example, if you move to a new house, your assets increase or decrease, tax laws change, or if the guardian or executor of the will is no longer suitable, you need to adjust the beneficiaries, or if your child turns 18, it is necessary to update the will. Of course, when major events happen in life, such as having a child, serious illness, separation, or divorce, it is immediately necessary to make adjustments to the will. I recommend that everyone should consult with professionals or lawyers who specialize in wills and estates. Being prepared can give you peace of mind, allowing you to live more comfortably, achieve reasonable tax avoidance, prevent family discord, or donate to your favorite charitable organizations. In short, regardless of your goals. Estate planning is very necessary. I have always hoped to use my knowledge to help everyone better understand the importance of financial planning. Raising awareness, life is extremely precious, and I hope everyone doesn't leave too many regrets for themselves and their families. I've seen too many clients who have insurance but no real protection. Having a policy doesn't mean much, and planning is a completely different level. We need to help clients identify problems and recommend suitable solutions. Those who know me well are aware of my attitude towards work. I hope to become someone like Lawyer Gray, and I also hope that everyone can take some time to listen more, read more, and think more. You can also choose to talk to me about your concerns, and maybe you will gain something from it. In the next video, I will introduce some arrangements that can be made in estate planning using our assets to decide how to manage and distribute them, simplifying and accelerating the asset transfer process, and minimize the impact of taxes as much as possible. If you're interested, feel free to subscribe to my channel. See you next time. Bye-bye.